Good morning, everyone. Welcome to this morning's Knowledge Bank. Today's webinar is going to be hosted by Francis Hunter, Senior Associate, CDM Manager and Health and Safety Lead at Ingleton Wood. Francis is going to be providing a presentation on the new and incoming requirements of the Building Safety Act. If you have any questions throughout the webinar, then please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as possible. The webinar is also being recorded today and will be available to watch back via the News on the Block YouTube channel. Without further ado, I will now hand you over to Francis to begin the session.
Thank you, Vicky. Good morning, everyone. Thank you for coming along, albeit a week later than we originally planned. Yes, this morning I'm going to quickly give you an overview of the Building Safety Act, mainly from the perspective of high-rise buildings and the expectation. Going to try and give you a bit of a briefing about where we are now in terms of where we stand today with current requirements, what is likely to be next, and sort of what we can expect going forward. As I say, particularly with a weighting towards the high risk building element of the Building Safety Act, which is obviously the most onerous part. So by way of an introduction, who am I? As Vicky said, I am the CDM Manager, Health and Safety Lead here at Ingleton Wood. I've been here about 6 years now, and started my career back as a CDM coordinator in health and safety, and with regulation change, made the transition across, now operating as principal designer. Under this new set of regulations we've got a principal designer under the Building Safety Act role, hence the kind of overlap and the match up between CDM and what we're doing here. Ingleton Wood as a company, we're a multidisciplinary construction consultant, architects, building surveyors, M&E, sustainability, structural engineers, all the rest of it, and alongside obviously our principal designer team. We operate. Some of you may have logged into the previous talk we did on this platform, which was my colleague Dean Appleton. He did a talk on fire safety and fire doors and the requirements and that sort of thing. So what we've done is brought back a couple of the guys who are on that, a couple of our building surveyors, Scott Barlow and Dan Legg, who are here. They will be around for fielding more specifically building surveying and fire orientated questions in the Q&A part. So what we're going to look at today is kind of listed out there. As I mentioned, the actual act in itself is far too large and far too overreaching to cover in a single session. So we've got kind of reduced it down to 4 kind of focus areas for today. An introduction to where it's come from, and all we have to do, quick look at the newest duty holders, the new regulator and what we can expect from them, and then a little bit about managing high-risk buildings, and hopefully answer some of those common terms that you may be seeing floating around, such as safety cases, the golden thread, that sort of thing, just to provide a bit of meat on the bone to those. And then obviously we'll pick up any questions that you've got. You can obviously drop those into the Zoom Q&A part, and we'll field those at the end. Any relevant ones that come in as I'm going along, I'll try and pick up as we go. If you have any specific questions that are extremely specific about your own buildings or your own projects or anything like that, my contact details will be available afterwards, and I can pick up specific inquiries like that. We'll try not to field those in front of everybody else today. So it all stems from the Hackett report, as you well know. Following the tragedy at Grenfell, we had a large review commissioned by the government, and this was to look at building regulations and fire safety in particular. And what the report came back with was a quite damning assessment of the construction industry and the industry for maintaining and managing all buildings, but particularly with a focus on high-risk buildings. Essentially saying our approach as an industry towards ensuring people have got a safe space to live is not good enough. And that was through items such as unclear roles and responsibilities. So there's a big lack of accountability, translating through the life cycle of the building from design into use, and then ultimately into refurbishment type environments that need to be happening. There wasn't a single kind of stream of accountability that ran through that. A big criticism on resident engagement and how we're getting those interactions with the people that live there. And competence was another area that was looked at. So inadequate levels of training, of experience, of people in roles that they shouldn't be in, delivering on these projects that had very real safety implications for those who were living there. And then finally there was a rather large arrow aimed at enforcement as well. How enforcement had been weak and not good enough, not coming in time to make any difference, and ultimately creating a problem where certain parts of the industry could get away with things, not doing things or doing things in an inadequate way. So as part of that review, we have a list, really, a shopping list of what needs to change with respect to building, refurbishing, managing and maintaining particularly high-risk buildings, as I say. The approach to our culture, responsibility, rather than taking ownership just for our bit. There's a push towards it's no longer acceptable to say, well, I did my bit okay, everybody else has caused this failure. So very much expectation under the Building Safety Act of a one-team approach, and as we'll kind of discuss later, that extends beyond a project team, beyond a contractor, and beyond just those that are managing. There's a lot more joined up between all those parts expected. A big change in industry practice is needed. A lot of the criticism and what the Act is trying to do is to remove some of this race to the bottom on pricing, and in that sense we need to have a rethink about the way contracts are procured, to make sure that quality of work, previous experience, competence are all weighted with sort of heavy reward over just being a low priced approach. And the competence is something that's going to be absolutely key as we move through this. All of the on the construction end of sort of the expectations under the Act, competence for all those duty holders, our designers, our contractors, our principal designers. There's British standards all coming in for those roles, or have come in, and it's going to be the same throughout the life cycle of the building. So for those managing the buildings afterwards, there's going to need to be an increase in competence and capability. And part of that inclusion now is about behaviour as well. So previously a lot of competence assessments were all around sort of skills, knowledge and experience, as you may have seen. The Act essentially pushes behaviours into that as something to consider as a factor as well. We also then have another side to how we look at competence, and that's the management of competence. So we're going to need to be as consultants proving our competence, but on the flip side, the clients or those who are engaging companies or individuals to work on their behalf under this will need to make sure they are also confident in the competence. That's kind of from an industry point of view, but the underlying theme in all of this is we need to do a lot better at listening to residents and giving them a voice in terms of what is happening within the spaces that they live, regardless of their kind of tenancy status within these buildings. It's pretty widely acknowledged that previously there's the concerns of those residents have been ignored. And I went to the Building Safety Regulator conference back in March, the first one, and that was very much the theme of the day. It's a very, very useful day. Lots of really great talkers there, and in fact was able to sort of lift some of the content into these sessions directly from the horse's mouth, as it were, over some of the more confusing or contentious bits. So that was really useful. But the underlying theme to all of the speakers from that day was about we need to do better at engaging with residents and listening to their concerns and worries as we go through. So today, where are we? Over a year ago now, the Act came into force, reached royal assent and became a thing under UK law. And we're now into a transitional period where secondary legislation is being introduced, being consulted on, and that will be the same way. I'll show you a little timeline in a minute. But it's essentially what it is a more stringent regulatory regime for England. It is meant to fix some holes in the building regulations and deal with all those aims that I just talked about in terms of adding more accountability into the industry and a much more joined up life cycle approach to buildings. It also establishes a new enforcement body known as the Building Safety Regulator. This has been established within the HSE and will be responsible for overseeing all building control, but also in the case of high-risk buildings will be responsible entirely for the building control of those. We also have a new national regulator created by this Act, and that is to deal with the quality of construction products. So we've got secondary legislation coming in for construction products and what can and can't be on the market within England. And as I mentioned, that secondary legislation programme is ongoing and being brought out sort of in 6 months increments every sort of April and October at the moment is as they go through. So we've got these aims really of the Act. This is kind of the oversight of what we're going to do. As I mentioned here earlier on, what we're going to focus on today really is to look at high risk buildings, because that's the first part of what we are needing to deal with now. That's the first part of the Act. That's deemed the most important. So the powers that have been created for this new regulator, that is to oversee the entire life cycle of a project. So you may have seen gateways being mentioned, gateways 1, 2, and 3. We'll cover that in our little diagram in a minute and what each of those means. But there essentially will be a step in the construction of high-risk buildings, 3 steps where the regulator will be involved and will have stopping points and will have the power to stop works and stop design and ultimately at gateway 3 prevent occupation of the building. So it's really, really important to understand what information that we need to be presenting at each of these stop points. This won't work the same way for refurbishment projects. We won't have to correspond to those gateways, and obviously there won't be those sort of prevention of occupation to do with refurbishment projects. So slightly different regime for refurbishment in existing buildings. But the other elements, like the golden thread of information, safety cases, that sort of thing, they will all still need to be in place for existing buildings as well. So we could kind of visualize the Act in this way. With this diagram, we've got various parts. Part 1 being definitions, etc. The part 2 of the Act is dealing with the creation of the new regulator, what their powers are going to be, panels, competence committees, things like that they're all obligated to set up. That's all encompassing. That's the whole industry. That's not just high-risk buildings. That is everything to do with any building control in the UK. That gives the new regulator powers over those. We've then got a part 3, which is corresponding to all buildings. So where we talk about competence, like the earlier on, our competence expectations are going to be for everyone within the industry, no matter the building that you're building. Higher risk buildings, or buildings in scope, as you may see them be referred to, that's all contained within part 4 of the Act. So you sort of see it nested in the middle there. There's a lot of sort of changes coming in, and then a particular sort of elevation of expectations for high risk buildings. So it's probably a good point just to stop there and define what do we actually mean by a high risk building. We're going to be referencing them quite a lot today. And under the definition, it's a building that contains at least 2 residential units which are 18 meters plus in height or have at least 7 stories. And we're counting that from ground level up. So a couple of diagrams here to explain this to you. We're measuring to the floor plate of the 7th floor. So we're starting from ground level. If you've got an unlevel ground, you take it from the lowest point of ground level. And if your top floor is all plant, then you disregard it as a story. So we're essentially going to the floor plate of the last floor that is occupied by residents. You know, if in this diagram floor 7 was completely just got a sprinkler tank and shoes and stuff all in there, but it's enclosed, then it wouldn't count as a high risk building. So that's kind of where that one is. And again, just another clarification really to show all sorts of questions that pop up and on these sort of, what my buildings, you know, this shape, how is this affected? We had a scenario where we had an A and B block with connected through a basement, say a car park or something. Under the Act, this would be treated as one building. The best way we've had it defined to us to consider, you know, what is a single block or not, is when it was constructed, was it constructed within a single building project, as it were, in which case, even with separate entrances, we would still treat this as a single high risk building, in this case shown here. So that's the buildings, and then this is then the process that now is going to apply to us. So we can visualize it as 3 separate phases of a building, and we've got the design, we've got the build, we've got the occupation of the building. So we can read the requirements in the view of, we've got those 3 elements of life cycle in a building. And this is where everything fits in. So we've got gateway, planning stage 1, that's already in force. It's already been used since August 2021. That's a requirement for the the safety regulator to be a statutory consultee under for fire, under high risk buildings as they apply. Interestingly, on the planning stage 1, since it's been brought into force, the HC have confirmed back that they've raised issue in 56% of cases, which is an indication of the scale of the job that we're going to have in terms of planning, designing and building these buildings going forward. Then within design, we have Gateway 2, which is the end of design stage. Before we move into construction, that's a hard stop point. Gateway 2 is where the regulator is going to assess whether the design is compliant and give a confirmation that it's okay to proceed. If an issue is raised there at Gateway 2, there is a stopping point and construction cannot commence. When we talk about commencement of construction, there is a lot of not fully worked out where that's going to be. At the moment, the working assumption is that we're talking from foundation upwards in terms of sort of the ground floor plate. If we've got a building with a basement going in, that can be started. So we're talking about construction of the upper floors in terms of compliance. So there will be enough time to get these approvals done without delay in normal circumstance. Hence, one of the industry concerns over this was that we were going to have sort of 12-week waiting periods to when the design's finished and when we can go on site. So that shouldn't be the case. Gateway 3 then is going to be the confirmation back to the regulator that the building has been built to in compliance with building regulations, essentially, and there is a pack of information that we'll have to prepare that will go with that building, much like the kind of O&Ms and health and safety files we already have, but with a little bit of an extra sort of onus put into that, and then that will be issued a certificate back to allow occupation. So again, a little bit of a risk there when we consider we could have completed buildings that haven't been signed off for occupation sitting empty, after the work's finished. So once we get out of the build section, we're then into occupation, and then we move under the reign of the accountable person, which we're going to go into presently. The accountable person is going to be responsible for the health and safety and maintenance, etc., of the building with respect to that throughout the life cycle, throughout the occupation of said building. And under that occupation section, we've got the requirement to register the building. We've got the requirement to prepare the safety case for the building, and we've got to apply for the building assessment certificate. Now, those are the three things that are all completely alien to all of us in terms of what we've had to do before. So those are the things that we need to focus on and understand. And a lot of that comes through, as I mentioned, the competence of the individuals. We are dealing with a brand new set of regulations and legislation, and we all need to be doing as much as we can to understand what those requirements are, but also to ensure the roles that we are put in, both as individuals and as companies, that we are competent to be doing. There's areas from a regulator point of view of control they're going to be put in place for competence, but very much the message coming out of those who put this together was that they expect industry to solve a lot of these problems. So in terms of competence standards, in terms of self-policing, there's an expectation on industry for those who are managing, maintaining, owning, building, designing these high-risk buildings, there's a lot of expectation for us to manage our own competence. And in that vein, we now have a requirement under there. This is one time I'm going to sort of show you a section of the regulation within this presentation. And that's because we now have a duty to refuse to carry work out. So when it comes to building work or design work for a building, so that's going to be from new build through to any refurbishment projects, through to any maintenance work that's going on. We have a requirement as individuals and as companies to refuse to carry out work on any building where there is not compliance with relevant requirements of the Act, and any design work on buildings where it cannot be carried out in compliance with all relevant requirements of the Act. There is a hard stop duty on us to refuse to carry out that work and say no. And as you can see the mention there when I mentioned earlier about behaviours now being factored in there. This will also filter into the new legislation on mandatory occurrence reporting. I'm not going to focus too much on that today, but essentially mandatory occurrence is when a duty holder under the Act is aware of a breach or something that is not compliant. They will have a duty to report those occurrences to the regulator, and that will be one of the things that is coming into force as part of the secondary legislation, and that will apply both to the project teams carrying out say any construction works at all, either to build or within these buildings, but also that mandatory occurrence reporting will also apply to the occupation stage of the building as well, and will require the accountable person to make that report where required. So where are we right now? This was one of those useful slides was managed to have shared out of the BSR conference, which gives us a real indication. There's a lot of confusion about what's coming in when. So as I say, coming directly from the horse's mouth as to when they're expecting to bring different parts of the Act in. It's really handy. So April 2023, where we are right now, registration for high risk building has opened. So all buildings that meet that definition of high risk building, the 18 meters, 7 stories, they must be registered by the 1st of October this year. You've got 6 months to get them registered. There is a link on government website to begin that application. It's £251 for the registration fee, and if any building that meets the conditions of high risk building is not registered by the 1st of October, then you will be it will be in breach of Building Safety Act, and can be deemed as liable to enforcement. So 6 months to get that in place. Once that is in place, as part of that process, there is the naming and the arrangements for the accountable persons. So come October, we're going to have the new duties in force on the accountable persons towards their high-risk building. In October also, the regulator will become the building control body for design and construction of high-risk buildings. So that will, anything that meets those conditions, the regulator will become the body for that. And in October also, the next stage will be to open register for building control inspectors and building control approvers, which will then flow through to April 2024, when it will be mandatory for those building control inspectors and approvers to be registered, and they will be assessed and etc. as part of their competence by the new regulator. That's it from a sort of building control perspective as to what we're doing in terms of high risk building. There are many other parts of this: construction products, regulations, for example, as I mentioned, also being consulted on. Really worthwhile keeping an eye out on the secondary legislation, the consultations that are going through. This is going to be this way for the next few years in terms of supporting this act and bringing it in. So we've mentioned them a lot. This new regulator, brief summary of what they're going to be doing, and put simply, they're overseeing the safety and standards and performance of all buildings. They'll have a remit to help and encourage the built environment industry and building control professionals to improve their competence. And then they're going to be leading this implementation of new regulatory framework for high-rise buildings, as we mentioned and define them, the high-risk buildings. And as part of that implementation, we've been mentioning a lot about accountable person. So the accountable person, who is it? They are defined in law in relation to the legal interest in the occupied high-rise residential building. And it's all about whether they've got an obligation to repair the common parts of that building. So any part of the building that is provided for common use, corridors, lobbies, staircases, basement areas, gyms within buildings, all of those that might fall under non-resident control, for example, would fall under that. It will not include the parts of the building that are either leased to individual residents or premises occupied for business purposes. So if you've got a building with a couple of ground floors of retail, say at the bottom, the accountable person will not have responsibility towards those areas. They will just have it within the shared spaces. It's important to note that this role is not something that can be assigned to someone else to carry out. It is inherent to the legal position of ownership. So depending on the structure of ownership, the accountable person will either be an organisation or an individual that owns or has repairing responsibilities for those common parts, or if the lease is structured in a way, the organisation where a lease obliges them to repair or maintain any part of the common parts of the building. So what that means is we can have multiple accountable persons within the same building, same high-risk building. Where the accountable person is an organisation, an individual within the organisation must be empowered to act as a single point of contact. Really important to note, and we're going to trip over this all the time, I imagine. Where we're naming an individual, it doesn't mean that individual is the accountable person. They might just be the one who is empowered to act in that capacity as a single point of contact. That does not make them personally liable. The accountable person under legislation will be the organisation who is, as we mentioned, either obliged to look after the common parts or is the owner of the building. So largely speaking, our APs are going to be local authorities, housing associations, resident management companies, common hold associations, right to manage companies, private ownership, all and everything all in between. Important to note that it's going to be in the main not passed off individuals. We are just going to have that single point of contact who's got that empowerment. Each building then will have to have a clearly identifiable AP, and this will be known as the principal accountable person. If we've got a building with just one AP, then they by default are going to be the principal accountable person. So there's kind of two levels to the duties, if you like. There's duties on all accountable persons, and then there's some enhanced duties for a principal accountable person. So in the buildings with multiple APs, it's going to be the AP that owns or is legally responsible for the repair of the structure and exterior of the building that will be the principal accountable person. This won't be up to debate. This will be however it's legally structured in terms of ownership. That's who's going to be the principal accountable person. So there won't be cases where there's a few different companies around the table in more complex scenarios and debating who's it going to be. There is a panel that can be consulted with and applied to when really complex scenarios where it genuinely is unclear, and the regulator will intervene and let you know in those terms. But that in the main, it's going to be fairly standard and obvious who that principal accountable person is. So as I mentioned, we've got the two levels here. So the duties on all accountable persons is going to be around assessing and managing building safety risks, and then implementing proportionate and effective control measures to manage those risks that have been identified. Duty to cooperate where there's multiple APs within a building, and obviously report to the principal with building safety in mind. APs will then have to provide information and documents as required to the regulator, to the residents of the building, and other interested parties, such as a design team coming in to work on planning some refurbishment works. They would have a duty to provide information to those. And when requested, they must be able to provide information and documentation relating to building safety to residents and owners of residential units within the buildings. So that's our duty on all the APs. So even if we've got multiple, each one within the space will have to confirm with those duties themselves. And then we have these additional duties on the principal accountable persons as well. The principals are responsible for the registration, as we mentioned earlier, worth reinforcing. Registration is open now, got until the 1st of October. Must be done. That is to be done by the principal accountable person. So for those who might be slightly behind the curve in terms of sorting all of this out, you've still got a few months left, but you will have to establish who your interested parties are, who your APs are from buildings, and who the principal APs are as well. So their duties will be provide key information about the building. When directed by the regulator, they must apply for a building assessment certificate. We'll have a quick look at what one of those is in a minute. The principal must produce the safety case report. So that's a mandatory requirement for all high-risk buildings, have a safety case report. Again, we'll have a quick look in what a safety case report and what it should contain. Establish and operate mandatory occurrence reporting system, as we mentioned. They must prepare a residents engagement strategy and establish and operate a complaints procedure for the building. So quite a step up in terms of levels of what's required for the principal APs within a building. So as we mentioned, the principals, where directed, will have to apply for a building assessment certificate. When that application is made, the regulator is the building safety regulator is the body who will be assessing those applications. And what they're doing is they are checking the legal duties have been met in relation to building safety risks. They're not assessing the safety of the building. Important to note there. that expectation sits with those who are responsible for managing and maintaining the building. So the regulator is not confirming that a building is safe. What they are assessing and checking are the building safety risks, so the spread of fire, the risk of structural failure, that those risks within the building are being managed effectively or not. So these applications will not, unless there's cause for concern, will not involve a visit to the premises from the regulator. They are assessing the process by which principal accountable persons, so the owners of the buildings, are managing their risk, checking that process, not actually the building itself. So the expectation, what we've got is that as registrations come through over the next 6 months, they'll start requesting for the certificate applications, and expecting to start assessing those from April 2024 onwards. Cannot nominate yourself, wait your turn type environment. So when required, the principal accountable person will be instructed that they need to apply for this. They will submit their application. Estimates of roughly 5 years to get through the current stock of existing buildings within the UK that meet the conditions of these requirements. The plan for the timing of when to invite will be done on a basis of height, size, and information contained within the registration. So a very risk-based approach to this, to try and get through the higher risk buildings first. And then there's an expectation at this point that there'll be a requirement to repeat this process at least every 5 years in terms of reassessment and keeping on top of those safety cases. Once invited, there'll be 28 days to submit the application. The application for the certificate must include a copy of the latest safety case report, a copy of the residents' engagement strategy, information on how mandatory occurrence system operates, and a statement confirming that all APs have supplied relevant information to appropriate persons. So there's that bit there where the principal accountable person will be confirming that everybody else involved has done their job, and they've also done theirs. So really important. You can see this kind of joined up theme that is starting to run through, everybody communicating a lot better, and then we're having this overarching organization in the principal accountable person taking ownership for ensuring that's going to be happening. The assessment will be a review of all information and documents submitted. If the regulator cannot get assurance from these documents that risks within a building are being appropriately managed, its next step will likely to be carry out inspection. Again, allowance for it to be virtual or a remote inspection if it's for minor things. It may just even be a meeting or a discussion with the principal accountable person. So it won't necessarily be a site visit as part of the inspection, but it could involve that, in which case the principal accountable person or the empowered individual from that principal accountable person will need to be available. And it won't be a general inspection of the building. It's going to be a targeted review of the issues found with the certificate assessment that was submitted only. So it's quite limited in scope of what they're trying to achieve with this. The criteria for those inspections is currently under development. Obviously, we'll understand more as we get more information. Important to note also, those inspections and site visits could take place as part of other regulator interventions. So it's not just going to be a case of the certificate application flags up problems, even if it doesn't. If we have, say, a resident's complaint come in, that may trigger the same inspection process, same review. And it doesn't affect the other existing legislation that's in force. So the other regulators, local authorities, fire and rescue service, they're still going to be visiting under their own requirements and their own legislatory demands. So once we've got the application, the regulatory lead will make a decision on that. If they're satisfied, the building assessment certificate will be issued, and it must be displayed within a conspicuous position in the building. So that's where it can be seen by everyone. If it is not satisfied that legal duties have been met from the application may be refused, and compliance notices may be issued, and then the application process will have to start again. If it's an issue that can be resolved quickly, then it will be, and it's very, very important to note here, refusal of an application for the certificate will not mean that the building is deemed unsafe. So it is not going to be saying that the residents within that building shouldn't be living there. What it is going to be saying is that one or more of duties under this Building Safety Act has not been met. So, for example, if you remember, part of our application has got to include the residents' engagement strategy. If our residents' engagement strategy doesn't meet the requirements of the legislation, the decision may be a refusal, and in order to sort that out, it would be about achieving a compliant residents' engagement strategy. And as you see from that, that would not be saying that building is not safe to occupy, even though it hasn't been, it's been refused the certificate. So again, having that communication with residents within these buildings is going to be really, really important, because without that understanding, because of the need to inform residents what's going on, if the certificate's refused, we're going to have to be telling the residents that the refusal's there, and we need to make sure we are explaining that in a way that is not going to cause upset or panic, or say, to make it seem like the regulator has said the building you live in is not, you're not safe to be in it, because that is absolutely not the case. So really, really important there. And how we're demonstrating all of this, and one of the biggest parts of the application, but also even where you're not required to apply for the certificate, the building, the accountable person must prepare a safety case, and the safety case is going to be a written record of how building safety risks are managed, the ones defined in the Act, so the fire, the structural, how we're managing those risks. The level of detail within the safety case needs to be proportionate, so we're not expecting volumes and volumes of information to be prepared. And key to note that if the building is being managed well already, and you understand the risks of the building, probably already doing exactly what you need to do. So there's a couple of terms, and again, clear up some confusion due to similar names. We've got a safety case, which is a requirement, and we've got the safety case report. The safety case is a term that refers to all of the information that we are using to manage building safety risks, and that information is a big part of what becomes the golden thread for the building. The safety case report is a summary of said information. So that is a report that is going to put in place evidence to demonstrate that you've taken the reasonable steps that you need to manage the safety risks, so the spread of fire, the structural failure. The report is to be prepared in conjunction with all APs for the building, and it will need to contain details of the assessment and what mitigation you have in place for the risks. So your mitigation measures are both going to be the physical measures. So, from explaining the fire alarm system or sprinkler system in, all the way through to the supporting management arrangements that you have in place, raising a complaint or raising a repair, that kind of thing from the tenants will all need to be included within the safety case report. View it as a report to make an argument with supporting evidence. It's not going to be a list of control measures or just a generalized folder full of reports and assessments and saying there you go. It's got to be summarized. It's got to link to the supporting evidence from your wider safety case, and it's got to make that argument and be a demonstration to the regulator. You've got a target audience of who's going to be reading this report, and it needs to be thought of from that point of view. So that's where the information is coming from. Your duties that you're going to have under Part 4 of the Acts need to be discharged with accurate, up-to-date information. Again, golden thread comes back into focus again. This is all about risk assessment. So don't forget that this is, although we're talking about a lot of management arrangements and information storage and how it's to be presented and keeping in digital format and all the rest of it, the whole intention is key to stay on the focus, which is controlling these fire and structural risks that are present within high-risk buildings or amplified due to the size, the number of residents, the height, etc. So examples of this information that need to include basic building information, how it was constructed, a profile of your residents, so particular vulnerabilities, that kind of thing will also need to be in there. Obviously, it's not talking about naming names within there, naming flat numbers with problems. It's about a generalized profile of the types of residents you've got, as well as ownership types for individual flats. So if they're tenants, leasehold, that kind of thing, we'll need to understand that within the resident profile. Details of previous refurbishments or change-ins that could have affected the safety of the building, the fire prevention and protective measures, structural safety, services and utility information for incoming into the building and how it's distributed without, and your maintenance and inspection schedules relating to fire and structural failure. So again, possibly information that you've already know about, already deal with. Within existing buildings, there is recognition that the standards for existing buildings may not match modern standards. It's not, this whole process is not about making APs responsible for bringing every building up to exact modern standards, how we would build it today. Well, what it is saying is it's not enough to say, well, this was the standard of building control at the time, so that's the standard that it's built to, and we're leaving it at that. There's things that can be done to improve the safety, and this is the general kind of spirit of the Safety Act, is to say, well, let's stop taking the easy way out, let's stop taking the cheapest way out, where it's possible for us to improve this and guarantee the safety of these residents. Let's do that then. So it's not going to be enough to rely back on that previous iterations of building regs that's compliant with those. We're still waiting for exactly how the safety case report is going to be set out, but some examples of the headings you'll likely have to include will be details of all your accountable persons, description of the building, assessment of your safety risks, so your risk assessment part of your fire and structural risks, steps you're taking, some mitigation measures you've got in place to manage those, safety management system for delivering maintenance works within the building, planning for emergencies, a demonstration you've taken all the reasonable steps, and then a sort of ongoing work, improvement plans. So again, your building isn't up to standard, the opportunity to say, no, we recognise that this is a risk. This is what we're doing over the next X amount of years to improve that. And again, that is not going to cause you issues. It's proactive and positive reporting of issues, and it's not going to prevent the certificate being issued in the circumstances where one's required if the improvement plan is robust and going forward. And this all links finally to what we're referring to as the golden thread. And the golden thread can best be sort of summarized by ensuring that the right people have got the right information at the right time. They've got that information, all of those safety cases, all of that design and build information that should be kept in a singular source. And then the system therefore can act as a single source of truth for that building. And we can think about it in terms of its digital, secure, transferable, and accessible. And the information requirements starts from the conception of the project. So we've got before the building work starts, all of that design information from before Gateway 1. That's when our golden thread of information is going to start. And the idea is you have a story that flows throughout all the way into occupation and beyond, and that is our golden thread. So we can sort of summarize that as our information that we're relying upon in preparing these safety cases. That is our golden thread of building information in occupation. So taking us from conception all the way through to people living there. And then so important to note as part of that, where you are undertaking building work in existing buildings, the impact of the work, the new requirements of building control on that work, including those additional information requirements, and the impact of the planned workspace when finished. All of that information kind of resets you back to the beginning of that process, and all of that then needs to feed into your safety case, and ultimately then adds to that golden thread that runs throughout. So what as we reach the end of this talk, changes in this legislation have come and further are coming to this industry, the whole industry, and no matter what part we operate. It's not going to go away. Building Safety Act is here to stay. We need to get used to dealing with it. So in summary, we've got some changes going through to the with the creation of the Building Safety Regulator. So that's the department of the HC overseeing the regulations and building control. New responsibilities on this new duty holder, the accountable person for the owners. Got that integration of the golden thread throughout the building safety management. So creating that link up between design, construction and occupation. We've got the need for our safety case process and our safety case reports. Approval for occupation. That's the 5 years reassessment on the safety case certificate. Important to note, it's covering new and existing buildings, and the pushback so far very concerning with resources and timing of getting all this in. But we've got a clear message coming out. We need to start preparing now. Once we go over this date, there is going to be little to no sympathy for those excuses later. So that's where we are in terms of the talk. Thank you very much for listening in. I will just pick up some of the questions that we've got in the chat. Right. So first one here, is there a complete list of what documents information should be contained within the golden thread to which I can refer? So we haven't got a full regulatory requirement in terms of what's going to be there. This question was asked at the regulator conference. As with a lot of these things, we are expected as industry to come up with a solution for a lot of these informations that we need to present back. Golden thread, think of it more as like the story of the building. In terms of the information you've got to contain, that's what's required within that safety case report. So we've kind of got that link up there. So refer to those headings, but as I mentioned, we don't have an exact list, and it's likely or potentially likely that we're not going to end up with an exact list of what that information is, and it's going to be down to us as industry to come up with what that looks like and present that back to the regulator in that process. And that goes the same for the mandatory occurrence reporting process. There's going to be a legal requirement to do it, but how that looks is going to be left up to it's going to be left up to the individual APs to work out how that looks for their building. Okay, what else have we got here? Are the safety case reports just for high risk buildings? Yes, they are. That is just in the case of the 18 7-story plus. We don't have to do that for others. There's potentially more buildings in the future that are going to come into scope, but for now, that's all we have to worry about. If we appoint a managing agent, is the agent the AP, or does it remain shared liability? Hopefully we kind of covered that one already with the multiple AP scenario. It's kind of all about who the principal accountable person is in terms of importance. So think of it more like a team effort for gathering information, and then that principal accountable person, that's the one who is going to be the owner who's got the responsibility for managing the common areas, or paying for the repairs in the common areas and the exterior. So generally that will not be moving away from being the outright owner of the building. If there is a separate freeholder from the RMC and the freeholder does not have a repairing obligation, but the RMC does, then the freeholder cannot be an AP. Is that correct? Yes, that is correct. So yes, the RMC would take the responsibility as the AP and PAP in that scenario. Can the building certification happen in Gateway 3, or must it only happen after the building is completed? The answer is that at this point, we don't know what those application processes are going to look like. It's in consultation at the moment for 2 and 3. So that will become clearer as we move in towards using it next year. In all likelihood, it's about the design information and confirmation that the building is being built to building reg standard. So it's likely that we can prepare the information for that certificate ahead of time, and then we're being assured that there isn't going to be a delay to occupation. I think the delays are only going to come to that occupation when there's problems with the case. So if we've got the design information done, we should be able to submit those, but so that will become clearer as we get that secondary legislation going forward. Next question, I'll take a couple more. Is the accountable person the managing agents and the principal accountable person the actual property manager? So the AP could be managing agents. Is going to depend on the structure of the individual building. The principal accountable person, as you referred back to earlier, is going to be that with the most responsibility. So I think building owner in that sense for the principal accountable, because they've got the ultimate responsibility for the exterior and common areas management. Does the Building Safety Act impose any additional regulations on buildings not classified as high risk? Yes, it does. So those are the competence requirements. I didn't get too much into that today. That's a whole other part of the topic of the Act. But yes, the Building Safety Act is going to be impacting all buildings in their own ways. A lot of that is to do with construction processes, design processes, and then through to the products regulations mentioned, and then also some of the defects, liability changes that are in there. So yes, there is an impact to non-high risk buildings. Last couple of questions. When it comes to flat doors where they are leasehold responsibility, would it be best practice for the freeholder block manager to provide a copy of the report to the individual leaseholder with a quote to pass on the responsibility baton? That's quite a tough answer. I think the Scott, you may be able to come in better on.
Yeah, that's fine. Yeah, I think that would come down to the actual wording of the lease. I think there would be, certainly it would be good practice to share any fire door inspection reports with the individual leaseholders. But obviously, I think it will come down to what the lease says with regard to enforcing repairs, statutory repairs by potentially the freeholder, because obviously there is a risk that although it may be the leaseholder's responsibility, they may not actually undertake the works, and therefore you'd maybe need to look at a repair notice to enforce those works, to ensure that the freeholders complying with their obligations under the Fire Safety Act. So I think it will come down to the wording of the individual leases.
And I think that largely answers the final question we've got, is the who's going to ultimately decide on what relevant defects are. So the question is basically giving an example where the freeholder may employ a surveyor who will support their point of view, whereas the leaseholders are going to have the opinion that the freeholder is responsible. And the question is asking, is there a mediator or someone to step in to ultimately define what, who is responsible, and I think that is going to come down to the spirit of what we're doing, and ultimately there is going to be that ultimate duty on the principal accountable person to make sure they are managing the building in a safe way, and having these disputes is not managing the building in a safe way. So ultimately, that, alongside with what Scott's just said about the lease conditions, need to be clear.
Agreed.
So yeah, that's all the questions for today. So yeah, thanks very much for tuning in, and thanks for all the questions. And now I'll hand back over to Vicky.
Thanks, guys. Yeah, I just want to say thank you to both of you, Francis and Scott, and the rest of Ingleton Wood, obviously for hosting today's session. Ingleton Wood have also got a few other webinars coming up over the coming months, so if you keep a lookout on the News on the Block website, then you'll be able to register for them shortly. I'll have a copy of the slides for everyone available if anyone would like them this afternoon, and the recording will also be available on our News on the Block YouTube channel. Otherwise, thank you for joining us. Thanks, Francis, Scott, and I will see you all soon. Bye, enjoy the rest of your day.
Thank you. Thanks, Vicky. Thanks all.
Bye.